And Courtney, this is not your first time with us. I think this is our second or third course together. So we appreciate you thinking of us and providing this. I want to turn it over to Courtney. Is it Buchan?
Buchan.
Buchan, dang it.
That's all right.
The same thing the last time. Courtney Buchan from GRS Community Management. The floor is yours, my friend. Take it away.
Thank you so much, Jeff. Hi, my name is Courtney Buchan. I am also a licensed community manager, but I'm currently the corporate trainer for GRS Community Management located in Lake Worth, Florida. GRS is one of Florida's largest community association management companies that manages and serves over 200 communities across several counties along the east and west coast of our Sunshine State. GRS has over 30 years of experience as a leading local property management company providing great, reliable service since 1989. If you're a fellow CAM board member or any other person that has close ties with the world of association management, we welcome you to today's presentation and hope to see you at future presentations. You can follow us on Facebook, LinkedIn, Twitter, X maybe, I don't know, Twitter.
Yeah, what are they calling it these days?
Who knows what it's called? X, Twitter, you know what I'm saying. And Instagram for more information on future webinar presentations. If you're interested in learning more about our management services, please contact our website at grsmgt.com. So today's webinar is, like Jeff said, is going to be about the screening process. And I would love to thank Kaye, Bender, Rembaum, attorneys at law, for providing this webinar for us today. So I am going to turn it over back to Jeff to go over some of those post evaluations after the webinar and how you can ask questions. So thank you.
Thank you. And before we introduce our instructor for today, I'm going to do a quick screen share here and show you how you will fill out the evaluation and get the slides. You don't have the slides now, but that's because we will be sharing them during the presentation. And then you'll have the opportunity to download and save them afterwards. In addition, if you're a CAM in attendance today, after we see that you've stayed for the entire class, and we can tell, so please stay for the entire class, we will take care of uploading the CEs for you at the end of the class. I will be doing that a little bit later today and get that done before September 30th, no doubt, so no stresses there. Just please, we ask that you hang on for the duration of the class. And one of the ways we can tell that you did and how we did and what we can bring to you in the future, because we want to know. We'll be putting a link into the chat towards the end of the webinar. You click on that link, it's going to take you to this page here. It's not as daunting as it looks. It just takes about a minute or so to fill out. After you hit the submit button, your confirmation screen is going to look something like this. It's a yellow shaded boxed area. This is not a requirement. You don't need to save it and print it. It's not a board certification class, but you're welcome to. It's your attendance certificate. You can click the bottom. Your printer dialog box will open up. You could send it to your printer or save it as a PDF. But here's the thing most of you will be looking for. In this shaded area, click here to download and save today's slides. You do that, and you'll be able to download and save them towards the end of the class. I'll go over this once again a little bit later. So for right now, I'm going to introduce our instructor. She is the managing attorney of our Tampa office location. Some of you may know her from her former location in the Pompano Beach office of Kaye, Bender, Rembaum. I'd like to introduce Kerstin Henze. Kerstin, take it away.
Hello. Thanks, Jeff. Thanks, Courtney. Hello, everyone. My name is Kerstin Henze. As Jeff and Courtney mentioned, I'm the managing attorney for the Tampa office. And today we're going to be talking about screening buyers, tenants, and potentially occupants. So let's go to the first slide.
And there we go. You should all be seeing that.
Can you move on to the, let's see, third slide, Jeff?
You got it. There we go.
Thank you. Jeff is in control of the slides today. All right, so what can we restrict? Okay, when we're talking about buyers, tenants, and potential occupants, the first thing you want to do is you want to confirm what authority you have to screen these individuals, okay? And unfortunately, Florida statute is silent on this point. Okay, so you'll need to turn to your governing documents to see what authority you have. And just as a quick review, your governing documents really are 3 documents, right? You've got your declaration of condominium or declaration of covenants if you're in an HOA. You've got your articles of incorporation and your bylaws. So your declaration of condominium or your declaration of covenants, that's going to be your constitution. It's the contract between the association and the unit owners or the homeowners that buy into the community. It is the document that's going to contain your use restrictions. Okay, that is a document that you really want to focus in when looking at what authority you have relative to new buyers, tenants, and potential occupants. Your articles and your bylaws, they really set out the corporate structure of the association. They're going to talk about, who qualifies as a member of the association, who qualifies as a director, officer, how you run your membership and board meetings, how you need to do your election, etc. So these are not the documents that really should contain use restrictions as it relates to buyers, tenants, or occupants. And then finally, you have your rules and regulations. Under Florida law, for a rule to be enforceable, it cannot conflict with the declaration. That's the first prong you have to pass. It cannot conflict with the declaration, and you have to have authority in your declaration or your bylaws to even have the ability to adopt these rules. So what we often see is that many communities have a lot of restrictions and procedures for screening buyers, tenants, and occupants in the rules, when really they should be contained in your declaration. So we'll talk a little bit about that later on, but rules really should be supplementing the authority that is already in the declaration. They should not be setting out these restrictions as it relates to these individuals. So some of the things that you will want to look for in your declaration as to buyers, tenants, and occupants is, okay, do you have the ability to approve and disapprove new buyers, tenants, or occupants? You'll want to look to see if you have the authority to require a screening or an application fee. So many of you may know that under the condominium statute, associations can charge an application fee up to $150 per applicant. So spouses are considered one applicant, and then dependent child and parent are considered one applicant as well. But you can charge up to $150, provided that the authority, again, is in your governing documents. Now, for HOAs, there's no similar provision in the HOA statute. So again, it's going to go back to whether you have that authority to charge that screening fee or application fee in your governing documents. You'll want to look to your declaration also to see if you have the ability to require a security deposit when it comes to tenants. Again, with the condominium statute, the authority to charge a security deposit for new tenants has to be contained in your declaration. HOAs, again, are silent on the issue. So again, you'll want to look to your HOA declaration to see if you have that authority. You might have requirements for a down payment that has to do with how much you can finance in order to be able to purchase a unit or a home in the community. You want to look to your governing documents to see if you have any move-in or move-out deposits as well. So these are some of the restrictions that, again, should be in your declaration. All right, moving on to the next slide. Okay. So what transfers are subject to approval? So for the most part, arm length sales, these are your, your traditional, your typical sales. You've got a sale purchase agreement. There is consideration. These are typically what we see in declarations that communities have authority to approve. Now, some declarations extend that authority to other types of transactions, such as, gifts. Gift transaction would be a conveyance that's done by a quitclaim deed. It's not necessarily considered a sale. An example of a quitclaim deed is if a parent wants to, add a child to the deed, or you just got married and you want to add a spouse to your deed. That's typically done as a gift conveyance by quitclaim deed. Other transactions that could be subject to approval are life estate deeds, or transactions that are done for estate planning purposes. So, for example, if an owner wants to add an owner wants to keep a life estate interest in the unit while he or she is alive, but wants to perhaps add, a child on the deed who will take title once the owner dies. Those are typically life estate deeds, and you might have authority in your documents to approve those, or you might not. Some transfers by operation of law that could be subject to approval. Inheritances, dissolution of marriages, foreclosures. If a mortgage, if a lender takes title to a unit through foreclosure, some documents actually exempt those types of conveyances from the sale, lease, transfer approval process. Tenancies or leases. Your documents might have the authority to give you the authority to approve leases. Or what about additional occupants? Family members. We'll talk about later, how you can possibly define occupants in your governing documents. Family members, sometimes your documents, we've seen documents where family members are exempt from the approval process. Some documents require approval. Doesn't matter whether you're a family member of, the buyer or the tenant. If you're moving into the community and you reside in the unit or in the lot for a certain period of time, you have to go through the approval process just like anybody else. Guests, they could also be subject to approval. Again, look to your declaration to see, how are guests defined? Is it anyone? Does it exempt family members? Is the owner required to be in the unit, residing in the unit with the guest in order for the guest to go through the approval process? Or are guests only required to go through the approval process when the owner is absent from the unit for a certain period of time? So these are the types of, transfers, individuals that the governing documents could typically address. Now, what can we do? So now that you have confirmed your authority to approve or disapprove certain types of individuals, buyers, tenants, occupants, now the question is, what can you do? Well, as the slide shows, typically it's three things, right? You can either approve the transaction, you can disapprove the transaction for good cause, or if you disapprove the transactions for reasons other than good cause, you'll have to exercise a right of first refusal. But let's just kind of go back before you even make a determination of whether to approve or disapprove an applicant, right? The application process starts with an application. Okay, so if you have the ability to approve or disapprove, your documents will likely grant you the ability to require some form of application process, which might look like, might require first the applicant to submit an application. And typically some things that you'll find in application are, the applicant has to identify all the occupants that will be residing with the individual. There might be a residential history that the applicant has to disclose, possibly character references. Some applications require applicants to acknowledge certain restrictions or rules. Some communities even require the applicants to sign off on certain rules, acknowledging that they've read the rules and understand them and will abide by them while they are residing in the community. And then some applications also will require an application fee to process the application. The application could also require the applicant to consent to a criminal background check or a credit history report, right? These are things that the applicant has to authorize in advance. Management will typically run the application through some third-party provider for the criminal check, and then also to issue the credit report. You'll also want, as part of the application process, to look at the governing documents, so look at your declaration and see what time limitations are set forth in the declaration as to when the board must render the decision on whether to approve or disapprove an applicant. So typically what we've seen is that the declarations require boards to approve or disapprove an application within 30 days of receipt of the completed application. Now, completed application means the actual completed application plus, once you've received the background criminal report and the financial or credit report. So once you've received all those documents that you need in order to evaluate the applicant and make a determination, that's when typically the time clock starts, right? So you might have 30 days, you might have 20 days or 15 days, whatever time frame it's in your declaration. But you want to check that time frame because typically the declaration will say that if you don't render a decision within that time frame, then the application will be deemed approved. Okay, so the association might be on the hook to having to approve the applicant if you don't timely evaluate and render a decision. Okay, so we've discussed the application process. Now you've reviewed the application, you've evaluated the background report, the financial or credit report. Now it's time to make a decision. Assuming everything checks out on the application, you might make a decision to approve the applicant, whether it's the buyer or the tenant, or the occupant if you have the authority to approve additional occupants. So typically the approval will come in the form of a written approval letter. Some documents might even require some kind of certificate to be recorded with the deed, or even a certificate to be attached to the approved lease. So you'll want to check your documents to see what requirements you have there. But what happens if you've reviewed the application and you've reviewed all these background checks and you've decided, you know what, this individual just doesn't seem to qualify under your governing documents, under your criteria, and so you want to issue a disapproval? Well, you can issue a disapproval based on good cause criteria, okay? And I've identified a couple of good cause criteria that are typically is what you will see in your governing documents, okay? I'll just briefly mention them and then we can discuss those in a little bit more detail. So one good cause basis for disapproval could be negative criminal history, negative financial history, or for example, if there's a violation of the governing documents on its face. For example, if your community prohibits, let's say, commercial vehicles, the parking of commercial vehicles, or you prohibit pets, and on the face of the application, the applicant has identified that he or she has a pet, or he or she has a commercial vehicle. Typically, that would be a basis, a good cause basis to disapprove an application.
Can I ask a quick question?
I'm sorry, go ahead, Jeff.
Yeah, and if this is a curveball, I apologize, but one of the thoughts that came into my head because of my history on the management side of things, does this also fit with housing for older persons, like a 55 and over? So let's say, like, for instance, my parents move out, they pass away, whatever it is, I get the house in the association. I'm not yet 55, even though I'm close, don't tell anybody. Is that's another basis for disapproval, or am I still allowed to own that home but not live there? How does that fit into any of this?
Well, that's that's a
Loaded
not
question.
an easy question to answer. It is a complicated answer.
Okay. Sorry about that.
There's a lot of dimensions to this question, but let me just try to simplify very quickly. And if you qualify as a housing for older persons, right, you need to be at least 55 years old or older in order to occupy a unit.
Yeah.
Then you're exempt from, the fair housing familial status protected class. That means that you can deny individuals who are under the age of 18 from residing there unless you have someone that's at least 55 and older, right? I'm sorry, let me rephrase that. You can deny anyone under the age of 18 from permanently residing in the unit. Now, anyone that is between the ages of 18 and 55 could live there so long as at least one individual who's 55 and older also resides there. Now, if on the face of the application, the applicant, let's say the tenant is, 30 years old, that could be a basis to disapprove based on age if you're a housing for older persons community, right? That
Okay.
would not apply if you are just a regular, non-protected condominium,
Right.
okay? Because as we'll talk about in a few minutes, age is a protected class and you can't discriminate based on age.
Didn't mean to jump the gun there. Sorry about that.
No, that's okay.
That question always comes up. I know we're going to get a bunch of those, so I just wanted to try to help us without this gazillion questions about it.
Yeah. If you are, I guess while I'm at it, sometimes you might get, if you're housing for older person, you might get an application from a buyer who is not 55, who's under 55 years of age. And there's this misconception that the board has to immediately deny the application because the applicant's under 55. The age restriction in that case does not apply to the purchase of the unit. In other words, someone who's under 55 could still buy a unit in a community that's classified as a housing for older persons. It's the occupancy that's at issue.
Right.
They just wouldn't be able to occupy the unit or the lot unless that individual is residing with someone who's at least 55 years or older.
Got it.
Okay.
Got it.
The other scenario that you kind of described, that you've inherited the property from, parents who are older, that's a little bit beyond the scope here. It's more of a complicated question. So if we have time, I might touch on it a little bit. Okay?
Again, apologies there, but I know it's going to come up. It always does with this course. So.
Yep. So where were we? We were discussing good cause criteria. Okay, so the last bullet point here is, false information included on the application. If an individual it checks off that they don't have a felony, and you discover that there's a felony, and assuming that's a good basis to disapprove that false information could be an additional basis to disapprove the application. But let's go back to let's go back to the beginning. Good cause criteria. It is so important that, and recommended that these good cause criteria be specifically expressed in your governing documents. Okay. That way, when you disapprove an applicant on any of these good cause bases, if they're already in your declaration, then there's less of an opportunity for the applicant and the owner to challenge the disapproval, right? Because we've already told you it's in the deck. These are the reasons we can disapprove. So you want to make sure to incorporate your good cause criteria in your declaration. Now, let's say you are one of the older communities and you have older documents, right? You might have the authority to disapprove, but you might not have the good cause basis directly included in your declaration. Well, again, remember we talked about those rules and regulations. Assuming you have the authority to adopt rules and regulations regarding units, not just use of common elements, but regarding use of units, then that could be your authority to adopt a rule that identifies these good cause criteria. And then at some point in the future, if you have the ability to amend your declaration, then that would be a good opportunity to incorporate those good cause criteria in your deck. But let's go back to negative criminal history, because that's also always a confusing point. So you get a criminal background report on an applicant, right? And it's like 20 pages long. Some are. And you're trying to figure out, well, my gosh, there's a lot here. I'm not sure whether this applicant qualifies to live here, right? Like, we just don't want a criminal living in our community. Well, let me just say, misdemeanors or arrests or charges, without a conviction or without a guilty plea are just not enough. Okay. Fair Housing Act and Fair Housing laws, like, these are just not, they're not good enough basis to disapprove. Okay. So you want to make sure that the criminal record contains felony, not just a misdemeanor, and that there's an actual conviction, right? And or that the individual has pled guilty, not just an arrest and not just a charge. Okay. And you want to evaluate every criminal background report, on a case-by-case basis. So you want to consider, the nature of the crime, the severity of a crime or the offense, how long ago it occurred, and any rehabilitation efforts. So it's not going to be, just one equation and then it fits all. It's going to be, you're going to evaluate this on a case-by-case basis. With negative financial history, that goes towards, is the applicant able to meet, their financial obligations to the association? Can they pay the assessments or any other financial obligation? So you want to look at, prior bankruptcies, foreclosures, bad debts, evictions, that type of information. Now, for a buyer, obviously, a credit report is going to be more important in valuing than perhaps, with the tenant. Credit score, that's another, hot topic. Many communities want to adopt a minimum credit score. No one, with a credit score below 750 can purchase in the community. Well, again, if you're a buyer, that might be more important, because ultimately the buyer who becomes the owner is on the hook, right, for all the assessments. And if the owner doesn't pay assessments, you can lien the property and foreclose. With the tenant, I'm not saying that it's not important, but you want to consider the credit score of the tenant sort of, in the totality of the whole financial history of the applicant. So, because if the tenant, for example, has a credit score that's a little bit less than what you typically require, remember that the owner's ultimately responsible for assessment, right? So it becomes less important with tenants, and even less important, when you're screening occupants, additional occupants. A good example of that is, let's say, son buys a unit for an older parent, right? The parent's going to be the occupant. The mom and dad's going to occupy the unit, but the son is the owner. I've seen communities where they, require the occupants to have a specific credit score. Well, again, if the occupant is just residing there and not, on the mortgage, is not the unit owner, then, the credit score of the occupant becomes less of a basis to disapprove the occupant. Okay, so so those are some of the bases for disapproving for good cause. But what happens if you disapprove for reasons other than good cause? Let's say you have you've reviewed the criminal history, and you know what? There's no felony, there's no conviction, but there's all these charges of misdemeanor charges or an arrest, and you just don't want someone with an arrest record in your community. Well, that might not be a good basis to disapprove an applicant. So if you disapprove, right, that's where the right of first refusal might come in. So let me just kind of backtrack a little bit and explain this, because it could be a confusing topic. So under Florida law, if an association wants to have the ability to approve or disapprove an applicant, a sale applicant or a transfer applicant, then you have to have a corresponding obligation to exercise a right of first refusal if you disapprove on the basis other than good cause. And that right of first refusal means that if you disapprove for reasons other than good cause, other than these criteria, then you have to provide a substitute purchaser or transferee. So you have to then find the purchaser, and sometimes it could be the association, if your governing documents allow, who's approved and is willing to purchase the unit under the same terms and conditions as the original transaction. Okay, so how this would play out is, let's say you issue a disapproval letter to, on a traditional sale. And you'll say on your disapproval letter, the applicant just failed to qualify. Then you get the owner's attorney to write you a letter. Okay, the owner's attorney will write you a letter, legally challenging your disapproval. And assuming it all checks out, that you disapproved for reasons other than good cause, then that's when the attorney might make a demand for you then to exercise a right of first refusal and provide a substitute purchaser to purchase the unit from his client. Okay, so if you end up, well, first of all, you really should consult with your legal counsel before you make a determination of whether to disapprove an applicant. And then certainly, if you disapprove an applicant without consulting with your attorney first, and you get a letter from opposing counsel, then certainly, discuss that with your attorney as to what your options are at that point. Okay. Now, since I'm mentioning here the a legal challenge, know this, that an applicant doesn't technically have standing to challenge a disapproval unless the applicant is going to claim discrimination. So unless the basis of the disapproval is discrimination, it's really the owner who's going to be challenging, or who has standing to challenge the disapproval. Okay. So let's move on to the next slide. Not sure why my mouse is not.
Yeah, technology is great when it works the way you want it to.
Oh my gosh. All right, potential liability. So All right, so we've established, let's say you have the ability to approve, disapprove applicants. Okay, potential liability. Some of the reasons that you cannot disapprove, we've talked about some of the bases that you can use to, or good cause criteria that you can use to disapprove an applicant. What is not a good basis to disapprove under is, for example, any of these protected classes that I've mentioned here. Under fair housing laws, protected classes include, and this is just among the many others, race, national origin, familial status. We briefly discussed that. That's familial status has to do with families with children under the age of 18, and only if you are a qualified housing for older persons, okay, can you discriminate on basis of familial status, which means you can prohibit anyone under age 18 from permanently living in your community. Sexual orientation, marital status. I mean, I've seen documents where they require couples to be married in order to qualify to live in the community. That is a violation of fair housing laws. Okay, that cannot be a basis of your disapproval. Disapproving based on a request for disability accommodation or a request for modification to the common elements. That's another basis you cannot disapprove on and could subject the association to potential legal challenge. An accommodation request can come in the form of what many have experienced, a request to keep a pet in the community that prohibits, a request to keep an animal, an assistance animal or service animal in a community that prohibits pets. Right? So if your governing documents prohibit pets and you get an application for purchase or for lease, and enclosed with an application is a letter requesting an accommodation to keep the assistance animal, you cannot deny that applicant simply because they are requesting an accommodation. You have to go through, normal procedures, whatever you have in place, or consult with your legal counsel about how to address an accommodation request. A modification request is one where an owner is seeking a request to modify, the common elements. For example, a buyer is purchasing a unit in a condominium, but needs, special railings or needs a ramp in order to be able to get into the unit. Okay, again, that cannot serve as a basis to disapprove that applicant. Another, source of potential liability here, notification requirements in the declaration we talked about. Make sure that you are familiar with any time frame restrictions set forth in your deck as to when you need to render a decision. Because if you miss that deadline, okay, the application will likely be deemed approved. Okay, and then you wouldn't be able to issue a disapproval after the fact. The owner will have a basis to challenge that disapproval. Fair credit reporting in Florida statute. Okay, this is, another important point. During the application process, you're going to get a lot of information regarding the applicant, personal information, potentially social security numbers, copies of driver's license, criminal background report, a credit history, car registrations, right? Sometimes you might have, passport pictures included in the application packet. Or you might have copies of prior year's tax filings, right? All this information that you've compiled in connection with an application, okay, under Florida statute 718 and 720 and 719 is not accessible to an owner and is not accessible to an applicant. And under Fair Credit Reporting Act, it must also remain confidential. So you can't and shouldn't disclose a copy of the credit report to the applicant, much less to the owner. Okay. So in your official records, make sure that you segregate all the sale, lease, occupancy applications, in a different spot so that when owners come in to do their records inspection, they don't by accident get, to this file drawer. So have them in a separate place. They are part of your official records. They're just not accessible to owners. Okay. So what you'll do is in a disapproval letter, for example, when you send out your disapproval letter, typically, so you're not going to disclose the credit report or the background history. The suggested language is that you notify the applicant and the owner that the application was denied because the applicant failed to qualify under the governing documents. And then you'll want to include in that denial letter the information of where the applicant can obtain a copy of the criminal report or the credit report, and then have them contact the agency directly to dispute any misinformation. Okay, but you're not going to disclose the report with the disapproval letter. Okay. Next slide. All right, so I mean, up to this point, we've talked about approving, disapproving buyers and tenants, but you might have the authority, or you might want to include authority in your governing documents to disapprove guest occupants. Okay, so you'll want to see how that term is defined, or you want to speak to your legal counsel about how you want to define guests. Typically, if we were to write an amendment to your declaration, we would define guest as someone that, after they've resided in the unit or the lot for a certain period of time, they're going to be deemed as a tenant, and then would have to go through the approval process just like a tenant would. Okay. Does the guest have to reside in the unit for a certain period of time? Any guest after, 30 days in occupancy has to submit an application. That's the type of language you want to look for in your governing documents. Immediate family, again. Does every immediate family, typically, spouses, children, or parents, if they come and, visit, or if they come to occupy the property after the initial sale lease application was approved, do they need to also be approved? These are some of the considerations that you want to maybe discuss with your legal counsel. Or you might want to exempt immediate family members from the approval process. That's really, on a case-by-case basis. Your community, how your community is going to react to certain restrictions. So you better than anyone will know if a restriction on, requiring every immediate family to be screened is going to pass or not. Non-related guests, again, goes back to immediate families. Do you want to have them screened as well or not? Some governing documents contain limitations, occupancy limitations. And if they don't, this is something that you might want to discuss with your legal counsel. You might want to include that. For example, number of permitted occupants by non-owners. You might limit, 2 individuals per bedroom. Okay, we've seen documents containing those types of restrictions. Duration of permitted occupancies. Again, how long does the occupant have to occupy a unit before they're required to get approval? Registration requirements. If your governing documents don't give you the authority to approve or disapprove an occupant, are there registration requirements? If they're going to reside, for a certain period of time, do they have to stop at the front desk, provide a copy of a driver's license, or fill out some kind of registration form? That's, again, considerations you'd have to, think about and perhaps discuss with your legal counsel. Again, non-overnight guests, use of facilities. Are they allowed to use your facilities or not? Or would they be required to use the facilities with, with the owner present or with the tenant present? These are some of the things you'll have to think about when you when you discuss the, what kind of policies and procedures you want to put in place. Practical considerations. If you don't have, for example, the authority to approve or disapprove occupants, right? You might want to survey the community to see if something like that would even fly in your community. There are many communities where those types of restrictions are, onerous, as considered by the members. For some communities, owners welcome it. So a survey of the membership, would be a good tool to see, how does your community feel about these types of restrictions? Lease renewals, that's another point. For example, a lease term has just ended and the owner has decided to lease the unit again to the same tenant. Do your governing documents require a renewal of that lease or any new lease with the same tenant to go through the approval process? Screening additional occupants, we've just discussed that. Use of facilities, again, access control, for anyone buying or leasing or any additional occupants occupying a unit in the community. Are they going to be required to register their vehicle? Are there key cards or fob system in place that you will need, their information that you might need to screen them for in order to allow them access, gate access, or any other front door procedures? Okay, enforcement. So assuming you have the authority to approve and disapprove all these applicants, what happens when an owner just decides to sell the unit or, let's say, transfer title in the unit to someone without the authority of the board, or to lease a unit without the authority of the board? That's when you might have to contact your legal counsel to see, enforcement options. Typically, if we're talking about removing a tenant or removing an occupant from the unit, you can bypass the arbitration mediation procedure and go straight to litigation. Typically, that would start with a demand letter, sent by the association, then by your legal counsel, with a formal demand that if the occupant or the tenant who's unapproved does not vacate, then you proceed with formal legal action. Depends on how egregious the violation. You typically would want to give the owner an opportunity to at least get that applicant screened after the fact before you take legal action to remove the occupant. Do your governing documents give actually authority to the association to evict a tenant? If you were to go through the litigation route, you would have to sue the owner, right, to force the tenant or the occupant out of the unit. But if your governing documents give the association the authority to evict, that means that the association could step in the shoes of the owner, okay, and actually file an eviction action against the tenant to get them out of the unit. That's a much quicker process and action than, formal litigation lawsuit. So if you don't have that authority in your governing documents, that's something that you might want to consider adding by amendment. And then if you have an unapproved, buyer or occupant or tenant, then potentially an enforcement option is to deny them access to certain common facilities, or at least until they have complied and submitted, their application for approval. And just to clarify, facilities would include things like, the gym or clubhouse, the pool, if you have the ability to control access. Otherwise, that might not necessarily be a good enforcement tool for you. So in conclusion, again, you'd want to confirm the authority that you have in your declaration. And if you don't have any authority, you want to speak to your legal counsel about adding authority through an amendment process, which will typically require membership approval. Once you have the authority, you'd want to establish procedures. Okay, put procedures in place. What is the application process that needs to be followed by the applicant? Registration requirements. If you're in a high-rise condo, for example, what access is given is going to be granted to these individuals. You want to act uniformly, consistently, right? You don't want to give owners the ability to have a claim of potential selective enforcement. You could delegate some of the authority to approve and disapprove applications to, let's say, a committee, or just one director, without having to have constant board meetings to approve applications every time one comes up. And again, you'd want to check in your governing documents to see what authority you have for establishing committees and adopting these resolutions. And lastly, again, understand the purpose and the extent of your documentary authority, and that if you don't have the necessary documentary authority relative to occupants, tenants, and buyers, that you can subject the association to potential legal challenge. Okay, so I think that covers it for this course. I don't know how we're gonna do questions, Jeff.
Well done. Well done. Thank you. And for the Q&A, let me just mention before I turn it over to Courtney, I know Courtney has a few questions that were submitted ahead of time that she has prepared and will present from our audience, but we also just enabled the Q&A. So the chat is disabled. We can send stuff to you via the chat, which I'm going to do now. I'm going to put the link for the evaluation that we went over a little bit earlier into the chat for everybody. So while we want you to stay for the Q&A, have a listen, but you're not required to. You're required for the course. The link is in the chat for the evaluation if you do need to head out. The Q&A is now functional, so you can type in questions pertinent to the topics covered today. But a couple of things to remember before I turn it over to Courtney for some of the questions she already has. That everything you heard today should not be considered legal advice. It is informational only. If you do have any questions about the topics covered today, you should consult with your association counsel. If you don't have association counsel, we'd be thrilled to help you out. Give Kerstin a shout. And Kerstin, before we turn it over to Courtney for the questions, so our host for the questions, what's the best way for folks to reach you?
You can call the Pompano Beach office. That's our main office. And the number is 954-928-0680. You can get that off our website. You call the main number and they'll direct the call directly here to Tampa.
Sounds great.
With a
Courtney.
switch of a button.
Yeah. Courtney, technology is wonderful. Again, when it works. Courtney, I'm going to turn it over to you. I know you have a few questions for Kerstin that came from our audience during registration, and there were a few questions in the Q&A now. So I'll take a look at those while you
Perfect.
handle some of the ones you already have.
Perfect. I don't want to take too much time. Kerstin, thank you so much. That was great. You answered actually a lot of the questions I had written down. I guess I just need you to elaborate a little bit more on maybe two things real quick. So you had mentioned that the buyer or the tenant's credit report or background is not accessible to the buyer or the applicant, let's say, the applicant or any owner. So does that also apply to the board? Because the board's owner, so I'm assuming yes, that the board does not, they do not have the access to those reports as well. Is that correct?
Well, the board is the body that's going to be making the determination. So the board has to review the entire application package.
Okay.
You know, typically, yes, the management company will provide the application, will run the reports, and then once you've compiled the package, then the board gets to review you know, the information. And yeah, I mean, it has to be kept confidential, obviously, from the rest of the membership.
Okay, so they are allowed to have access to that. Okay, I was not sure. And another thing, how long, oh, actually, no, this is a better question that I had. If an owner, I think Jeff had kind of touched on it, but not pertaining to 55 and older. What if an owner dies and in their will, they leave their home to a family member? Does that family member, one, have to still go through the application process for that home? And two, if they do have to go through the application process, and I'm assuming they do, what if they don't meet the criteria of that application? What happens then?
So, you know, again, we have to assume that the governing documents allow the board or, you know, the association, the authority to approve and disapprove these specific types of transactions, right? Because it's not a sale, it's not a quitclaim deed, right? It's a devise and inheritance situation. And many communities actually exempt that from the approval process, simply because, you know, the argument I keep hearing is, you know, why does, you know, my son have to go through the approval process? You know, this is my unit. I should be able to, you know, devise it and leave it to my children, you know, without interference. But let's say you do have the ability to approve these individuals. The declaration really should set out almost like a right of first refusal procedure of what needs to be followed in the event that individual is disapproved by the board because they failed to meet the criteria. If there's good cause basis to disapprove, then, you know, this could be a scenario where the heir needs to look to sell the unit.
Okay.
You know, and there's a lot of it, you know, it's a bit of a complicated answer because, again, is the individual going to actually occupy the unit, lease the unit? Is it just holding on? So these are considerations that the board will need to factor in.
Gotcha. Well, thank you so much. I want everybody else to have time to have their questions answered. So that's all I have for right now. You've been so helpful. This was a great presentation. Thank you for going over everything so thoroughly.
Courtney, thank you.
My
Thanks for
pleasure.
thinking of us when it comes to presenting some of these courses. We look forward to doing some more.
Yeah.
And I did turn off the Q&A because we have a limited amount of time left. I think we advertised until, I think we have another 13 minutes or so left in our advertised time. So I've got about 8 or 10 questions here. And let me see here. This one is kind of vague, but maybe you have a couple of ideas, and either one of you can answer these, because this seems like more of a rules and regulations kind of thing versus a specific to association documents. But do you have any suggestions regarding approvals of short-term, and in parentheses, this person has vacation tenants? In my mind, this person's alluding to something like Airbnb. It sounds like they're having an Airbnb issue. So what are some suggestions that you might have that associations can do to help avoid Airbnb taking control and investors coming in and purchasing a ton of properties.
That's something that that will require an amendment to your declaration, essentially, to tackle these short-term rentals. You want to look to your deck to see, not that it prohibits, commercial use, because this is not really a commercial use. It's not considered a commercial use, but you want to look to your deck to see that you have lease terms in place. How many times can you lease in a year? What's the minimum lease term? What is the maximum lease term? We often see, you can lease a unit for, nothing less than 30 days. Well, that obviously, could potentially open you up for these short-term, Airbnb type of leases. So the best way to tackle that is through an amendment process to put in place some lease terms.
That makes sense. Makes sense. And I'm sure, Courtney, as a management company, you face a lot of this quite often, having to consult with your other managers and the council that you work with, including Kaye and Rembaum.
Yes,
Yeah.
definitely.
It's an issue, especially in Paradise where y'all live. So this question, stemming back to the discrimination section earlier in the slide deck, is where I think this question comes from. If a special needs person buys a unit and wants ramps, wider doors, etc., pays for these extras. I'm guessing, Kerstin, that has to do with whether the association is already in compliance with requirements already or not, correct? Like accessibility, stuff like that, to like common areas?
Not sure what the question is, really.
I guess the person's asking who pays for these extras. If a person buys a unit and wants ramps, wider doors, who's going to pay for these things is what the question is. And I think it stems back to when we were talking earlier about the discrimination and special needs people.
Yeah. General answer is if an owner, if an applicant is the one that's requesting the modification to your common elements, then they are responsible for the cost of those modifications.
Okay.
And I'll just leave it at that, because
I guess
complicated question, complicated response.
Yeah, without knowing, again, try to keep questions not so specific to what your documents might be saying. I guess that's more of a general statement. I guess this one here, same snowbird renter each season for several years. Can a condominium require an application and fee every year? Is that something that the law allows?
That would again require an amendment to your declaration if you don't already have something like that. That's not really something that the law speaks to. That is a covenant that would need to be in your declaration.
Okay. Figuring it needs to be in there. I guess that person wanted to know if the law allows for something like that. And you mentioned that it doesn't really touch upon it. So if it's in your official association documents, I guess it would be okay to do, being that there's nothing that says you cannot do it.
I guess I'll piggyback on that by saying that both HOA and condo statutes do speak to one thing, that if you have an amendment, if you're going to propose an amendment that restricts leases or affects the term, the duration of the lease, these would apply only to those owners that approve the amendment, that vote in favor of the amendment, and those owners that take title to the unit after the amendment becomes effective. So there is that limitation. Okay. In terms of to whom the amendment will apply once it is approved by the requisite number of owners. But in terms of the nature, the substance of the amendment, that's something you'll need to speak with your legal counsel about incorporating your deck.
And John, your question about the 80-20% rule, the 55 and over, pose that question in the evaluation, because that could be a class all by itself. Let's see here. Enforcement is always a problem. Associations are reluctant. Associations seem to be reluctant to obtain legal counsel, which is, look, I come from one time where I was working many years back on the management side of things, you try to do more for less. You try to provide more and charge less in your maintenance. That tends to become more of a mess. More for less always becomes more of a mess. Try not to skimp. I'm going to ask this question anyway, but gosh, I speak from experience. You want to try to do things the right way, even if it costs you a little bit more now, it's going to save you a lot later.
Mm-hmm.
But this person wants to know, are there any alternatives to legal counsel? Talk about more of a
There is no substitution
No
for legal
substitute.
counsel.
Zero, none.
Zero.
No, but really, joking aside, that
No,
becomes
and you have to be very careful in asking your managers for, questions that could be construed as them giving you legal advice, because they're not licensed to practice law.
this is for you,
Most of them, in my experience, right? And so, the managers could be getting themselves in trouble,
right,
by giving legal advice without a license.
right.
So you want to get legal advice from Florida licensed legal counsels.
And, which Kerstin is licensed to do, but even what we say with these courses, and when you watch our videos on demand or GRS's videos on their website, these courses, even though given by attorneys, these are not to be considered legal advice. Even with things that we present today, if you're not 100% sure on what you need to do, consult your association counsel. Again, it will save you a headache in the long run.
100% agree.
Let's see, does it need to be in your docs to establish a committee to do interviews? So, okay. So I'm guessing for an association to establish a committee for screening interviews, does something like that need to be in your documents, or can a board just form a committee? Is how I interpret this question.
If I was to write an amendment to, if we were to start from scratch, and I'm drafting an amendment to give the board the authority to approve, disapprove these types of applications, then I would just incorporate something like that in the deck. But if you already have the authority and you have rulemaking authority as well, then it's possibly something that you can adopt as a policy, right? To supplement the documentary authority that you already have. So you might require, in addition to submitting an application, and I wouldn't call it an interview, but more of a meet and greet with the board. You want to be careful and not to necessarily meet the applicant before you've made a decision. I think there's a lot of exposure there. If you end up disapproving the applicant after you've already met them face to face, it's easier for the applicant to claim discrimination. So just generally, as part of your application process, you want to review your application, make the determination, and then if you've decided to approve the applicant, then have that, meet and greet, interview. And really the basis for that would be just to go over your rules, your policies, procedures, covenants, that type of thing.
Right. I see Courtney nodding. That's something that comes out quite a bit as well.
Yeah. Well, I wouldn't call it an interview. I'd say it's an orientation, right? An orientation.
Exactly.
That you have to approve that first, and then you'd have the orientation.
Right.
So I've seen that a lot.
I normally don't name drop people that I see in the audience, but there's one person I know very well on here. I'll just go by the first name, Tim, and he works in a community I'm very familiar with, and they do some wonderful things like bus tours of the community, getting to know your community, driving around, meet the board. They do some wonderful things, and that's something I wish every association would do, because an educated owner, an educated board member are your best residents.
Yep.
Okay, here's a loaded question, but again, Paul, we teach a course on this all by itself. Do emotional support animals have the same authorization to enter public spaces as service dogs? And I guess this stems from when we were talking about animals a little bit earlier.
I'm gonna go ahead and not answer that question. But like you mentioned, Jeff, like we do have seminars that's just focused on this topic.
Yeah. Okay, we've been told by legal counsel, it's not for this, right? We've been told by legal counsel that the association is not permitted to run a credit check since we don't have a financial interest in the lease agreement. Has that changed?
Well, again, that goes back to what documentary authority you have relative to, lease applications. If you have the authority to screen, right? Then if you have adopted a credit score, again, assuming you have the authority in your document and you have the ability to adopt rules concerning unit use, you have a minimum established credit score, you can consider that as a basis to disapprove. But that shouldn't really be the sole basis for disapproving, especially tenants. Again, credit score becomes a little bit less, I don't want to say less important, but not as important, as when you're screening a buyer who's ultimately on the hook for all the financial obligations to the association that comes with purchasing a unit in a community.
Okay. It's the last couple of questions here, which will round us out because we have three more minutes in the advertised time. How can we define, this is a general question, how can we define the composition of family members? For example, a brother-in-law, a cousin, is that something, can they get really specific in that? Or is that going to be like borderline discrimination, that kind of a thing? Like if the documents say a family member can stay here, are they able to get specific with what kind of family member? I don't think so, right?
I mean, you can define family members, and typically, it would be immediate family members, which would extend to, your spouses, your children, parents, and grandchildren.
I did not know that. I've been doing this for a gazillion years like you, and I didn't realize that you could get that specific. That's cool. If an applicant has a felony, this is the last question, from 10 plus years ago, how much weight should that have? I guess that's up to the committee, right?
Yeah, that's a hard question to answer here. I mean, you'd have to review the totality of the criminal record or criminal report, the type of conviction, the type of, I'm sorry, was there a conviction? Did he plead guilty? What kind of crime? How long ago it happened? Rehabilitation efforts, all those good things.
Okay. Well, Kerstin, great job. I know it's been your first Zoom class in quite a bit. You haven't missed a beat. You haven't missed a step. And for those of you who are going to be in the Tampa area the end of October, I think it's the 24th and the 25th, myself, Kerstin, Michael Bender from the firm, we're all going to be at the Bradenton trade show, the Tampa trade show, presenting a couple of courses, including Kerstin, hot off the presses, our 2024 legal update just got approved. So we have that as well. And before I go over the evaluation process one more time, I'd like to turn it back over to our host for today, Courtney from GRS Management, for some parting words.
Thank you so much, Deb. I hope everybody got so much out of this course. Again, Kerstin, thank you so much. You did great. Jeff, you're amazing as usual. For any of you guys that don't know, he is the best at what he does with the media and marketing management over at Kaye Bender Rembaum. So like I said, I'm Courtney Buchanan. I am the corporate trainer for GRS Community Management located in Lake Worth, Florida. If you need to reach me, my email is C, as in my first name, Courtney, my last name, Buchanan, BUCHAN @grsmgt.com. I look forward to working with you both in the future. I know that we have some plans for future webinars, so audience members, be on the lookout for that as well. Thank you so much.